Today, we are going to be talking about COVID-19 and restrictions to free movement in the European Union, and we will focus on Schengen. So as we all know, the pandemic had dramatic consequences on human mobility and border controls worldwide. The Schengen area was no exception. So today's presentations will explore the current situation regarding the reintroduction of border controls in the Schengen area, the role of the EU in reinforcing and maintaining free movement, on the implementation of these measures, and the consequences for European public opinion and for security. We are very happy to welcome today 5 recognized experts on this topic who will contribute to the debate from very different disciplinary and policy perspectives. We will begin with the presentations that are more policy focused, and then we will move on to the more academic perspectives that will focus on specific topics. So I will introduce to you now the presenters in the order in which they will present. The first presenter will be Matthias Oel, who is the Director of the Directorate General of Migration and Home Affairs, DG Home, at the European Commission. And he will provide us with the policy perspective and the future policy responses of the European Commission. The second presenter will be Sergio Carrera, who is a part-time professor at the Migration Policy Center and is also the head of Justice and Home Affairs Unit at the Center for European Policy Studies, the CEPS, in Brussels, who will present the key findings of a study for the European Parliament on the assessment of Schengen border controls. So he will give us the big picture of how the restrictions are happening right now. Then we will have Lenka Drašanová, who is a quantitative political scientist and is also a research associate at the Migration Policy Center. And she will focus on public opinion. Lenka was recently part of the team that published a few weeks ago a report examining the state of play of Schengen governance for the European Parliament as well. So she will tell us more about that. Then we have Evelien Brouwer, who is a senior researcher at the Amsterdam Center for Migration and Refugee Law of the Vrije Universiteit Amsterdam. And she will provide us with a more legal perspective and will focus on technology interoperability. Then last but not least, we have Michela Cecorulli, who is a political scientist and is also senior assistant professor at the University of Bologna. She will focus on the security aspects of border closures, and she will talk about the Italian case. We remind all the presenters that they will have a maximum of 7-8 minutes for their presentations, and then we'll have Q&A. And I remind also the attendants that you can write your questions in the chat on the right side of your screen. I will now give the floor to Director Oel.
Thank you very much, Leza, and good afternoon, everybody. Let me upfront reply to the headline question of this seminar: is Schengen in crisis? I would say the COVID-19 pandemic has certainly led to a crisis within the Schengen area in spring, but at the same time, it has opened a window of opportunity to launch a reform. Following consultations with stakeholders, the Commission therefore envisages to table a Schengen strategy on reform in May next year. But let's start from the beginning. 2 general remarks. First, there can be no doubt that Schengen is one of the biggest achievements of European integration, and a recent Eurobarometer shows that it is cherished by the vast majority of European citizens. Second, Schengen is the nucleus of and the reason for many of our EU initiatives in the area of home affairs. Why do I say that up front? Because we decided on the subsidiarity question already 35 years ago when we founded the Schengen area. In an area without borders, it does not make sense to set cross-border relevant law on the national level. In other words, in a borderless area, cross-border relevant law must be set on the EU or Schengen level. And that means at the same time that the external borders of one Schengen country becomes the external border of the entire Schengen area. And that is why we need well-functioning systems on the European or the Schengen level, whether in the areas of borders, asylum, or migration. And we need trust in the well-functioning of these systems. We need to develop a habit to think Schengen, not only when the sky is blue, but also when we are confronted with problems. And over the last 5 years, three events or three phenomena have contributed to the decrease of trust. In 2015, it was the mass influx towards the EU. In the last years, several terrorist attacks in several member states have led to security issues or concerns. And this year, the COVID-19 crisis demonstrated shortcomings in the Schengen system. And the increasing lack of trust can be underpinned by just two figures. Between 2006 and 2014, so over 9 years, internal border checks have been reintroduced 35 times. Since 2015, so over 5 years, internal border checks have been reintroduced 205 times. 35 times, 205 times. Can there be more evidence that there are apparently problems we need to address? At the same time, the COVID crisis this year has opened a window of opportunity because the reintroduction of internal border controls has drastically demonstrated what happens if Schengen comes to a halt. In other words, the COVID crisis has drastically demonstrated that a strong Schengen area is essential for the well-functioning of the internal market and our economy, more specifically for the post-COVID economic recovery. So it's much more than free movement. It has a lot to do also with our economic success. So what do we intend to do? What do we need to do? To build up trust, we need to openly discuss issues of concern. The Commission kicked this process off on 30 November with the first Schengen Forum, bringing together the Commissioner, ministers and members of the European Parliament to reflect on a reform of Schengen on the political level. And there was broad agreement in the Schengen Forum on the topics requiring joint action in order to make the Schengen area more efficient and more resilient. In the first quarter 2021, targeted technical consultations will take place in order to further deepen the issues raised during the first forum. And in April, we intend to organize a second Schengen Forum in order to wrap up the topics discussed in the technical consultations. And what are these topics we need to address? First, on the external borders. This is probably the area where over the last 5 years, most progress has been made. And external border management does therefore not primarily require new initiatives. It rather requires to focus on implementation. On the implementation of the new IT architecture and interoperability of the external border management systems, and this should become operational by the end of 2023. Second, on the implementation of the standing core of the European Border and Coast Guard in order to have support for the frontline member states at the external borders. And third, there is also a need to reinforce procedures to ensure that nobody enters the EU territory without being checked. The second topic concerns the Schengen governance. We need to make the Schengen evaluation mechanism more effective and efficient. The Commission's 5-year report on Schengen evaluation and the study recently published by the European Parliament provide a good basis to further discuss and to revise the legal framework on the Cheval mechanism. The third topic is crisis management, and this is very much linked to COVID. We need to reflect on a contingency plan to limit the risk that possible future crises may again disrupt the area of free movement. It is important to react in a quick and coordinated manner whenever an EU-wide crisis calls for it. If you have an EU-wide crisis, national measures do not work. We need to coordinate. That's what the COVID crisis has shown to us. Fourth topic, the checks at the internal borders. Already under the current Schengen Borders Code, internal border checks must be measures of last resort, and existing controls need therefore to be lifted as soon as possible. But at the same time, we have to take into account the concerns raised by the above-mentioned crisis. Therefore, we need to reinforce current alternative measures to border controls, and we need to reflect on additional ones. For example, we need to consider reinforcing police cooperation within the Union. We need to exchange relevant data between law enforcement authorities. The use of new technologies must be ensured for the protection of our citizens and at the same time for the facilitation of travel. Additional joint work in the area of security research is desirable. And it goes without saying that technologies must be managed in a transparent manner and in a manner compatible with our data protection rules. Last but not least, we need to update our legal framework, in particular the Schengen Borders Code, which is today no longer fully fit for purpose. Let me conclude, the COVID-19 crisis has demonstrated the need to reform Schengen. The discussions will be politically complex and sensitive, but as I said at the beginning, we have a window of opportunity to do so. Thank you very much.
Thank you very much, Director. Now it's the turn of Sergio Carrera.
Thank you very much. I will be using a PowerPoint presentation that I'm sharing now. So my presentation is based on a European Parliament study titled In the Name of COVID-19, where we studied the state of play of Schengen internal border controls, as well as extra EU travel restrictions introduced in the name of COVID. And we assessed that in light of the legality and proportionality and non-discrimination principles, which lay at the basis of European law and the Schengen area. So our overall findings, we identified that in the beginning, in March, April, May this year, we saw the initial responses by a large group of member states was containment, meaning border closures, internal border controls, and border closures, in a rather unilateral, ad hoc, and uncoordinated way. And we've seen since then a move towards surveyed mobility, meaning travel restrictions not focused so much on border controls and border checks, but rather policing and surveillance of all travelers and their data. So the concept of data surveillance may be useful here because every traveler is under surveillance, meaning that there is also this priority given to police checks against technology, databases, and electronic information, which make use of risk assessments, profiling, and statistical, sometimes discrimination. In our finding, in our study, one of the findings is that despite the fact that we are all targeted by these measures, some groups feel them more strongly than others. And here, migration status and also asylum seekers and refugees seem to be more negatively affected. Now, very briefly, at the moment, is Schengen in crisis? Well, I wouldn't think so. And the study concludes that no, it's not in crisis, Schengen. The proof is in the fact that at the moment, very few, a very minor group of member states are still exercising internal border controls in the name of COVID-19. A very small group of these countries, a majority, consider this as disproportionate and unnecessary. What we have is a whole range of travel restrictions still, as we are now witnessing from one day to another in a unilateral, still ad hoc and uncoordinated way. We see, for instance, new restrictions on mobility, be it prior entry or post-entry, consisting of quarantines or in-country testing or pre-traveling testing, and with very little consideration as regards the effects that these measures have parallelly when looking at them parallelly on people. Now, there is also some member states using passenger locator forms. So the airports become central hubs of mobility surveillance, and also even temperature screenings at airports. And national data protection authorities have identified how some, if not many times, these forms and screenings do not find legal basis. There is no legal basis in the law, and there is no consideration on privacy impacts of these measures, as well as effective remedies for people. What it was very interesting in our study is that, in light of these internal border checks and travel restrictions, there is actually not much evidence about the extent to which these measures are consistently and coherently applied across the EU. In fact, the evidence tells us the opposite, that these measures are sometimes in a very inconsistent way, discretionary way, applied, left in hands of police authorities, and certainly not being put in practice every single time. So we raise the question, both as concerns technologies, meaning surveillance measures, but also former border controls, the extent to which they are realistic and actually feasible to implement all those measures into practice, despite what we hear from the authorities and the media. And it's true that the European Commission has really made a huge effort, particularly with the proposal of recommendation towards a coordinated approach on restrictions, member states' restrictions on free movement, which was adopted by the Council in October. And here the Commission was really highlighting how some principles are legally binding for member states, not only as Schengen members, but as European Union members. Basic principles of the EU legal system, such as principles of non-discrimination, proportionality of these measures, focusing on access to healthcare and medical treatment instead of refusal of entry, and also having some common criteria amongst EU member states, which, as we speak, we see is so difficult still nowadays to ensure in practice. We see now the situation in Germany and the Netherlands, and the discussions that this is raising in countries like Belgium, neighboring countries like Belgium or Luxembourg. But if anything the study brings forward is that all the member states that have engaged in internal border controls and extending those internal border controls in the name of COVID have failed to provide evidence substantiating the necessity, proportionality, and non-discrimination of these measures, as well as the existence of less restrictive means. This is also something that the Commission and the European Parliament have highlighted several times, saying that there may be other measures which may be better equipped to what is a health issue. There's nothing to do about migration status or checking, the border control in itself. Also, member states have made use instrumentally of the legal basis provided in the Schengen Borders Code. The Schengen Borders Code is a wonderful, excellent, high-quality law. It's very clear what the obligations are for EU member states to reintroduce border controls, as well as their obligations in external border controls. The simple fact is that they have not complied with those rules. Many of them are not complying with those rules, and we are seeing quasi-permanent border checks being introduced, and also an expansionist use of public policy and internal security in what is a health issue. Now, when it comes to travel restrictions, these may actually have equivalent effects to formal border controls. So it may become indirect barriers to free movement. So we need to really assess carefully. And in the study, we recommend to assess very carefully, particularly those travel restrictions which are compulsory and are applied systematic, the extent to which they actually prevent or constitute border controls. This is a subject that is currently being considered before the Luxembourg court. When it comes to passenger name record, the EU PNR, the question being if a surveillance information system where you have such a generalized data collection is equivalent to border controls. My personal view is that yes, it is equivalent to border controls as long as it is applied in a consistent and systematic way, and it also raises fundamental questions regarding incompatibility with privacy and EU data protection. Now, previous research, and I'm sure my colleagues later will develop on this, has already showed that police checks inside the Schengen area usually target more people more than others. This basically entails racial and ethnic groups and people with migration status. So the Commission recommendation for member states to put at use police checks needs to be very carefully tailored and assessed in light of the reality that in some member states you do have risk-based policing and arbitrary practices. And there are a couple of cases pending both in Germany and the Netherlands on this, the existence of racial profiling and biases in the ways in which identity checks are conducted in internal border areas. So our study says or concludes that COVID-19 can be seen as a magnifying glass of previously existing discriminatory and policing practices. And the last slide, coming back to the topic of asylum seekers and refugees, this is also has been very well documented, and our study also brings light to the negative impact that COVID-19, travel restrictions, and border measures have on the right to seek asylum in the EU. Greece and Hungary are not the only cases. This also relates to many other EU member states. The reality is that we have overcrowded, at times accommodation and very poor hygienic conditions, unsatisfactory, to say very politely, reception conditions, and no access to healthcare for people who actually need to have access to healthcare and medical treatment. And some travel restrictions more negatively or disproportionately affect people seeking asylum. For instance, in some member states, requiring people before entering a medical certificate, providing negative COVID-19 test. I mean, how can we ask that? Or having proof of suitable accommodation in light of the reality that the reception conditions there are no reception conditions in many member states which are satisfactory to uphold human dignity. So to recommend, we actually say in the study conclude that Schengen is not in crisis, that what is needed is more enforcement of existing standards, timely enforcement, and more accountability of what is happening in practice on the ground, including internal border areas. The Schengen evaluation mechanism is an excellent tool. Of course, there is room for improvement in the Schengen evaluation mechanism, but we recommend to expand the applicability of Schengen evaluation mechanism to internal border controls and in-border police identity checks, and also have more of a registering of what are the grounds, the specific reasons why police check the identity of certain people more than others. And also something that has been actually also presented in the new pact, Commission Pact on Migration and Asylum, which we also confirm the need to have an independent and effective complaint mechanism for individuals encountering border controls, but also disproportionate travel restrictions, which should not go to the detriment to access to justice and data protection authorities. I will leave it here. Thank you for your attention.
Thank you very much, Sergio. I remind everyone that you can write your questions on the chat on the right side of your screen. Now the floor is for Lenka.
Okay. Thank you very much, Liza. So my contribution will be about where does the public stand in all this. So as you probably noticed, in many member states, the public discourse about the EU appears to be much more salient and polarized than in previous decades. The Constitution are the prime examples of this, as well as prime examples of how attitudes of the general public can actually strongly influence European politics. So when we talked about attitudes towards the EU, these are composed of several dimensions or sub-attitudes, if I may, such as Europe's asylum policy, even attitudes to globalization when it is understood as an increased movement of goods and money and increased movement of people. And of course, attitudes to the freedom of movement in the Schengen area. Overall, the public attitudes towards the EU depend on how much each of these different dimensions composing these general attitudes count. For instance, attitudes towards the EU can represent a trade-off between the sustainability of the welfare system because of the contribution of foreign workers versus the potential labor market competition. It is precisely these expectations about economic outcomes, either at the individual or societal level, that are shown to result in varying attitudes towards the European integration. And actually linking the EU's liberal labor market regime to higher labor market risks is particularly effective in undermining support for the freedom of movement. So although it is commonly assumed that a series of EU crises, such as the Euro crisis, the Schengen crisis, and Brexit have led to a backlash and Euroscepticism among the general public, research shows, in fact, that political attitudes such as those towards immigration or the EU remain stable, and that the crisis did not reinforce the link between the rejection of immigrants and rejection of the EU. And especially regarding attitudes to immigration, we see that especially in Western Europe, they are very stable and actually becoming quite positive in recent years, which comes as quite as a surprise to the general public. This is based on data from one of the highly regarded. But while in recent years there have been an increase in academic research regarding attitudes towards immigration and asylum policy, we know much less about attitudes towards border regime and Schengen in particular. So unfortunately, there is this lack of data. However, I would like to show you some very recent research. This is from this year's Carton's article, and regarding support for the current Schengen border regime, by which we actually mean open borders, not the closure of internal borders that some countries introduce. And as you see here, where actually darker colors mean more support for open borders, for example, France, and even Italy are much below the average member state in supporting open borders, whereas Spain, but even Germany, who was particularly hit by immigration from outside the EU, and the introduction of internal borders is quite a salient topic in Germany. Still, Germany is above average in supporting open borders within the member states. We also there has also been this data comes from Eurobarometer, and there has also been a discussion in countries that actually did reintroduce internal borders in recent years. What does the public think was the reason for that? And it's interestingly, as you can see, it's actually in all the countries but France, the public believes that internal borders have been reintroduced to discourage people from coming illegally to their country. Whereas in France, on the other hand, the majority of the public believes that it was to prevent terrorism, and which kind of reflects the official reasoning of the states why they actually have reintroduced their internal borders. So as I mentioned in the beginning, sometimes the public opinion can influence the politics, but it also goes the other way around. So sometimes the official reasoning of the states can introduce the public discourse. And finally, as we do not have much time, what we unequivocally observe is that the support or rejection of free movement and border controls goes hand in hand with the how strong is the national or European identity of the respondents. So either national or European identity is a very significant and powerful predictor of attitudes towards the EU in general and the reintroduction of the internal borders. So those respondents that feel that the absence of border controls is a threat to the national way of life are very much in favor of restricting freedom of movement, whereas those respondents who exhibit some European identity, they actually support the Schengen membership much more. So from this, we might conclude that actually the endorsement of Schengen and even further European integration depends very strongly on an inclusive European collective identity. So this is from my side, and thank you very much for your attention.
Thank you very much, Lenka. Very interesting findings. Now we move on to Evelyn.
Unmute. Sorry, wrong screen. Thank you very much. And also the organizers for this opportunity, which I think is very important under these circumstances, to be able to remain exchanging thoughts and information. I would like to talk to you about what was already targeted today with regard to the possible alternatives with regard to first reintroduction of internal border controls. Like the speakers before talked, how do we have a crisis in Schengen with regards in COVID and the previous crisis, migration crisis, with regard to the reintroduction of internal border controls. And I am targeted because of the announcement, which was also mentioned by Matthias in the new Commission communication on the new Migration and Asylum Pact, that emphasizing the strength of Schengen and emphasizing the importance of Schengen as core of the European integration, it is important to think about, as the Commission mentioned in the communication, that as an alternative, controls based on risk assessment or local police measures are possible. And also it mentions the use of new technology and smart use of ET, information technology, and interoperability as measures which are less intrusive. And that is the core question, and I will only pose and submit questions to you, maybe for further discussion. Are those controls really less intrusive? And it's interesting because the Dutch version in the communication speaks of discrete powers, whereas the French and the German and the English version, and I don't know about the other languages, but those 4 languages I do understand, they really talk about less intrusive, meaning less intrusive for data protection, privacy rights. The German language, for example, is quite clear on that. So that is the main hard question, I think, which really should consider when considering available tools of today, but also the tools in the future. And I will also address not only interoperability and the use of databases as an alternative of internal border controls, but because of Schengen is, of course, so much connected with the external border controls, also raise some points with regard to the general use of databases. Well, just a reminder, what do we have now? For most of you, and I think the public, it is known, but for those who are not so in following the last years of development and the adoption of legislation, I just repeat, we did already have the large-scale databases like the Schengen Information System, Sergio referred to this, the Eurodac on asylum seekers, the visa information system for visa applicants for short-term visa. And the last 4 years, since 2017, we added 3 new large-scale databases, which are not operational yet, but will become in the near future. And it's the entry-exit system. Every third country national entering, exiting the European territory. ETIAS, it's about the non-visa applicants who should apply for a travel authorization. And we have the ECRIS on third country national, which is a criminal record system, but according to the law which has been adopted in 2019, may also be used for immigration purposes. I add to that Schengen Information System, Eurodac, has been amended or will be amended in future, adding new functions. And as already mentioned in the first presentation, those databases will be made interoperable in 21 or 20 or 22, 23, when everything technically is developed further. What I also like to remind you, and I do this also for my students when I'm talking about databases and right to data protection and privacy, why did we develop in the first place those instruments? And the time is too short to go very much in length, but I want to emphasize the fact that those databases initially had more fine-tuned, or not fine-tuned, but specific purposes, like the visa information system, controlling access of travelers, preventing illegal entry or stay, but also facilitating legal migration. So if you're a visa applicant, it can also be easier if your data is already in a visa information system. Eurodac is about determining the member states responsible for your asylum application. So in asylum policies, to make sure that one member state knows which state is responsible for the asylum application. Well, I don't want to go because of the time, but law enforcement, sorry for the mistake on the slide, law enforcement, criminal and justice cooperation. We have PRUM, we have of course the PNR data law. And meanwhile, 2020, we see that all those databases have changed into multi-purpose tools, because the immigration databases like Visa Information System, Eurodac, have been made accessible for law enforcement purposes. And as I said, the real criminal records system like ECRIS TCN has been made from the start available for migration purposes. Well, what do we know? And that is why, what do we know about the use, when we're talking about Schengen and the COVID crisis? What does these information tools help us at external borders? And it is clear, and Sergio mentioned it already, the Schengen Borders Code is quite clear that public health can be a refusal ground. That is, it's included in the Schengen Borders Code. It is also in the Visa Code, which is based on the Schengen Borders Code, and even allows to report data on the public health as defined in the Schengen Borders Code. And the Schengen Borders Code, as we know, has a reference to these, when are you considered as a threat for the public health? That is, if you have a disease which is defined as a pandemic health risk or disease as formulated or listed by the World Health Organization. Also ETIAS, so this travel authorization law, which will be in future applicable, also refers to the high epidemic risk of the applicant as a refusal ground for travel authorization. Well, you see in the future, I think there will be more, because of course what we have experienced in this year, more emphasis on this risk of public health in the new migration pact. We see it in an asylum screening proposal. There will be a preliminary check on health risks, and also the involvement of the central information repository. That's a database which is a part of this interoperability scheme. So at the external borders, we see partially this health risk as provided to be informed. In the internal borders, with regard to the controls at the internal borders, this was already pointed, there's no real rule in the Schengen Borders Code for the member states to reintroduce border controls when there is a public health risk. But states did so, as we know, and which has been discussed earlier, but on public security risk or internal security risk. But the question is, do we have, and Sergio raised this point already, can we really speak of a crisis in the Schengen? Because yes, the member states did reintroduce their border controls. They did it temporary. Most of the states did this. But they also ended this, and we have the recommendations of the European Commission also to trigger the member states to do it only when there are appropriate grounds. So the question is, because of the internal border controls, which has been reintroduced, but also only in a limited time, do we need those databases as less intrusive? Is it really less intrusive? And I raised some points that you can concern, and it was raised already by Sergio also with regard to the non-discrimination human rights, that those third country national databases, as I just showed you, only affect third country nationals. Only the ECRIS on third country nationals includes EU citizens with a dual nationality. That's another legal problem on the individual right of EU citizens on free movement. And I agree with Sergio that this is a problem for free movement in general. So this case, that's where my last slide will be important as well. But there's this bias, and already reports of the Leiden University indeed showed that these controls, which are triggered, in my opinion, by the use of those 6 large-scale databases, which can be checked also within the territory, will risk the further increase of bias against minorities. Only people assumed to be a third country national or a migrant or a regular migrant will be controlled. The data protection, I think, because of the massive amount of data, the sharing with a massive amount of national authorities in a large number of member states, is problematic. The purpose limitation, which I showed, but in a very short time we have written there on it, is problematic. So because of this interoperability, which is a further blurring of the purpose limitation, every database will be used for migration and security purposes. The risk of contaminated data, inaccurate if we talk about public health and the COVID, whether you tested positive or negative, it's clear for everybody that if you start registering that, it's not reliable in one, maybe even already one day, it is not reliable. The lack of transparency, the accountability, whose data. I was in a meeting with data protection officers of Frontex, of Eurojust, and there was already a problem of which supervisory authority is responsible for checking and making sure that the data are used for proper goals and not misused. And I don't mention security, etc. Because of the time, I stop. So I really want to stop with this remaining question when we talk about interoperability, but all this massive use of databases, the access to those databases, the fact that they will include stop and search at the internal border areas. I think we really should raise the question, are the use of technologies, and I didn't mention facial recognition, the use of smartphone, the tracing of smartphone data, because that's all, I could go on for hours about all the future and tested measures for external border use. Are they really less intrusive than reintroduction of internal borders controls if they are checked and they remain temporary and the Commission performs the role that internal border controls really are temporary and only for the rules which are included in the Schengen Borders Code? And also how to ensure that with those use of those databases, we really realize the sufficient safeguards against abuse and that are only necessary as performed by the Court of Justice. And if it's not, if you can't answer these questions with a yes, I think there is a problem, and also future cases, as already was raised on the PNR agreement, but not only on the PNR agreement, I can think that there will be more cases before the Court of Justice. And I think this is a task for the legislator to prevent that. Thank you.
Thank you very much, Evelyn. Thank you very much for rounding up the findings. I remind our viewers that your questions are more than welcome and you can write them on the chat box. Now, finally, we have Michela.
Yeah, thank you. Thank you to the organizers for having me, and thank you to the speakers which have shared these their inputs, which are very interesting and somehow they fit in my presentation too. So when I try to somehow started to think about the webinar today, I wanted to reflect a little bit on the theoretical perspective of the question that the webinar is posing us. So is Schengen in crisis? And I wanted to rephrase a bit the question into, does the European Union perceive Schengen to be in crisis? This is a fundamental point for me, because it leads us to a preliminary question, which is Schengen securitized today? Do we believe that Schengen is of such value that a potential danger can somehow shake the fundamentals of the European Union? And in trying to somehow consider the answer to this question, I think we have to go back to what has been happening since 2015, and in particular since the migration crisis of 2015. So what has happened in that context is that, first of all, Schengen has been securitized, and there was a kind of urgency which was perceived by the European Union to save Schengen. That was very clear. It was made particularly clear by the European Commission, by the European Council, and also by the European Parliament. However, after this first securitization, there has been a kind of particular security governance response that was given, and that was relevant because it somehow paved the way for a certain new normality that somehow has led to the situation that we have today. And so what was the securitization about at that specific moment? So first of all, when we think about securitization, we have to think about a process. And first of all, we have a normal discourse and normal practices. So discourse and practices about Schengen. And then we have somehow a securitization move that is being made. In this case, we try to see whether Schengen has been securitized. Then we have a process of recursive interaction between the European Union and the member states, whereby the security move is being accepted by the broader public. And then what follows is a security governance, which tries to provide an answer to the securitization move, and then a new normality, which is somehow unfolding. So if we consider what happened in 2015, we have to consider that a first securitization move has been made after a situation where the normality was the absence of any border control. So the normal discourse and the normal practices of the European Union was that the Schengen area is an area without border controls. The Schengen Border Code exists for specific exceptions. And previously, as it was mentioned before, there were basic no violations of these principles. So that was the normality going on. But after that, in 2015, and with the trigger of internal arrivals, the fear for security of secondary movements has led many member states to reintroduce borders control. All of a sudden, the first and main attention of the European Union was on how to cope with this situation. Schengen has been securitized. There were announcements that Schengen is in danger. We have to go back to normality. We have to go back to order. We have to go back to Schengen. So Donald Tusk was saying, saving Schengen is a race against time. And we have many documents, and the most important is the document Back to Schengen, which were making clear that we have to go back to what we know is good for the European Union. What we know is one of the major and most important achievements of the European Union, and this is Schengen. However, there has been a kind of disconnect between this securitization move that has been made, so the urgency to bring back order, and what has followed, so the security governance that has followed. The security governance was mainly to try to climb and to somehow bring back to normality what was perceived to be an exceptional measures. So eventually Article 29 was triggered, and a strong reliance was made on external measures, on external border control and external border strengthening in the form of a fast tracking of the European Border and Coast Guard, of important meeting and contacts with the Balkan countries, and the basic sealing of the Eastern Mediterranean corridor. So that was to bring back order into the Schengen space. However, what happened since 2015 is that some of the member states have kept controls on their borders. They have kept these controls even in here of no exceptional arrivals. And so the question were multiple about whether that was a last resort measure, whether these borders were proportionate, and whether this would be a new normality. Why it is important? Because if this is a new normality, then there is no urgency on the part of the European Commission and European institutions to change the situation. So this is not bringing any haste in shifting what is going on. This, of course, has many implications. So we can think about a kind of a lost securitization, which may seem strange, but which is actually very important to notice. There seems to be that the European Union has not reiterated the urgency that was perceived in 2015. So how borders no longer a threat for the European Union? This is a fundamental question. If we look at the documents, in particular the documents published by the European Commission in 2017 on the reform of Schengen, it was mentioning that we have to adapt the Schengen system to new threats on the forefront, and in particular to migration challenges and terrorism challenges. And therefore, we have to provide something which is more in tune with member states' concerns. However, this position was not widely shared in the European Union. In particular, there was the European Parliament, which was strongly in opposition with this position. The European Parliament was saying borders persistence are unlawful, so we cannot accept border controls. And no matter how many measures we have taken at the external border, and no matter how many measures we have enforced at the external frontier of the European Union, yet member states keep on persisting with their policies on borders. And this is not answering the main question that we have. The question that we have is deeper and does not relate with an external event, or not mainly with an external event. It is a kind of an internal problem that we have here, and that somehow has been feeding with many other internal challenges that we are facing today. So what we see in 2020 is kind of no securitization from the part of the European Union, at least not in the terms that has been evident in 2015. And this is quite problematic in that the benefits of Schengen have proven to be particularly relevant in a period of pandemic. So the importance of having Schengen clearly outweighs its dangers or its supposed dangers. So what is the situation today in terms of borders control? Here is a document of the European Commission of 2020, and these are the borders that have been reintroduced because of COVID. On the left side of the slide, and on the right side, the borders which have been reintroduced because of secondary movements and therefore migration and terrorist challenges. So what do we notice here? And here I'm coming to a conclusion. Are borders a new normality? And here I'm relying somehow to the question that has been posed about is Schengen in crisis. I'm slightly more pessimistic about this question. So borders and their persistence are clearly providing disorder within the European Union. We have a kind of overlapping between old and new borders, often shifting from a legal basis to another. There seems to be not of last resort. There has been an extension beyond time, and they have been mostly introduced unilaterally. Second, another problem is borderization. The increasing reliance on borders is somehow giving a nod to nationalist or populist movements. So how really borders the panacea of many of the problems we are facing today? And also, is this a kind of self-feeding process? And here I'm referring particularly to the Italian case. Over the last months for Italy, it has been particularly complex to face the incoming arrivals in its territory of mainly migrants coming from Tunisia because of the economic and social unrest. Because of COVID and the strengthening measure at the borders, it has been very impossible to go on with the Malta Agreement of 2019, which somehow prescribes the relocation of asylum seekers. And this has put many strength to Italy, also because of a kind of a discomfort within the public opinion to accept migrants, even though they are not positive to COVID. So this can have the effect, paradoxically, to further disincentive the erasing of internal borders. And in fact, this has been proven true when Austria has further strengthened its border towards Italy. Also, a lack of confidence in the European Union. Is the European Union still able to handle crisis, and are member states relying to the European Union to face crisis? The situation seems to be that the first move is always the closure of borders, and then eventually the European Union steps in to correct something that is not working. And finally, we are still relying a lot on external measures, on external borders measure, as it has already been said, and this has by no means reduced the incentive to have internal borders. To the contrary, many member states have been emboldened in their willingness to keep borders control. So the question that we have to face now, which is urgent, I think, is, are we still saving Schengen by applying Schengen, as it was mentioned back in 2015? So attention should be particularly paid to what the direction of the Schengen strategy, which is going to be coming soon, is going to take. Many thanks for your attention.
Thank you very much, Michela. Thank you very much to all the presenters. As the director all has to leave us, I will ask him. I will try to ask him two very brief questions and see if he can briefly comment on them. We have Monica Weissensteyer, I hope I said it well, asking what are the Commission plans regarding a possible reform of the Schengen Borders Code, and for Arno to Italy, asking what will the European Commission propose to reinforce the nexus between border controls and checks on public health grounds? That is, reinforce the Schengen Borders Code to that regard.
Yes, thank you very much. On the reform of the Schengen Borders Code, of course, we are, as I said, entering now into consultations with all stakeholders, and we will see what comes out of that, and then we will reflect what we will propose under the Schengen Borders Code. But what I can say already now is that, of course, we had negotiations on the proposal of 2017, which has been stuck in the negotiations. And we draw the conclusions, what could be reached already there with the European Parliament and the Council, take that into account. I also mentioned that we will see, which consequences we draw from the COVID-19 pandemic with regard to the fact, that an EU-wide phenomenon like a pandemic requires also an EU-wide action. Meaning, that the problem in March was that this EU-wide phenomenon occurred, and then each member state decided alone. And then we had a totally discoordinated situation, which was, as I said, in spring, a real crisis. Lorries were stuck. Pharmaceuticals could not be brought to the different member states, to the citizens. So we needed then to coordinate under soft law, because the Commission doesn't have a competence in this really. We just coordinated in order to bring member states together. And I think here we have to reflect very much in the Schengen Borders Code, and the rest we will make dependent on the consultations now with all stakeholders in the upcoming months. And the same applies to the second question, to the police checks. But let me maybe, if you allow me, to have 1 minute also to react on what the co-panelists said in a way. For me, our Schengen reflections do not start in 2015. Our Schengen reflections need to start 35 years ago when Schengen was founded. And as I said, 35 years ago, it was clear that an area of removement requires EU-wide systems. And up to 2015, we managed to build up a common European asylum system, etc. But in a way, we found out that we built sailing planes. They fly very well when the sun is shining, but when there is a first thunderstorm, as happened in 2015, they do not function anymore. So they are not strong enough. And that applies to our border management, that applies to our Dublin system, that applies to the common European asylum system. And that is the reason why we now table the Pact on Asylum and Migration, why we table the Security Union strategy, in order to protect the integrity of the Schengen area. And that requires now that we build up an external border management system which is modern and which is up to date and state of the art. And that is the entry-exit system, that is ETIAS, that is the reformed Schengen information system, that is the reformed visa information system. And internally, we have to create a situation, and that is what the reform is about. Internally, we have to create a situation which makes internal border checks superfluous. And that means I have to think Schengen-wide, and Schengen-wide means I have to establish police cooperation. I have to establish a cooperation of the law enforcement authorities. I have to establish the use of modern technologies, because then I build up the necessary trust in order to make these internal border controls superfluous. And let me say one thing, the EU probably has the best data protection rules worldwide. We have the principle of proportionality, we have the principle of non-discrimination, and each and every action by the police can be checked by the courts and can be checked in an administrative procedure. All this is guaranteed. And that's why I'm not in line with what Sergio said, who says, we should not go for further police check because the police is acting racially. Sorry, if there are single cases where this happens, these cases can be followed up in court proceedings. But this is not the rule. These are very single cases. And that's why we need to improve and increase the police cooperation. But we need to do that applying the principles of data protection, non-discrimination, proportionality. And we are not a banana republic in the EU. We have a well-functioning legal system. And I think we should also have confidence in that. That would be my short comments. I apologize that I have to leave, but I have another meeting which started at 4 o'clock. And I thank you very much for the invitation.
Thank you very much to you, Director All. It was great to count with your participation for this seminar. Now, I will move on to other questions. We have several questions for all the panelists. For instance, we have our colleague Ettore Recchi, who is asking Sergio and all the rest, if they want to comment on this, if there is any evidence of different treatment by law and practice of returning nationals versus other EU citizens at internal borders during the COVID crisis, independent of their health conditions. Then I will ask all the questions together so that we can sum them up. We have KHS asking Sergio Michela, regarding the dependent complaint mechanism, how do you assess the mechanism at external borders foreseen in the new pact? We have Martin Shine, I hope I said it well, asking Sergio, have you seen what the Commission is doing in respect of complaints concerning de facto closing of Schengen borders? He's speaking about Finland and the indigenous Sami people. And then also we have a question from Monica saying, how are some of the criticalities mentioned in the second contribution, which was, Sergio's again, is the question refers specifically to internal border area checks and police cooperation. I would like to ask Evelyn if she could further elaborate on country differences, if she would like to comment on that. The floor is yours. We can begin with Sergio and we can follow the order of the presentations.
Thank you, Lisa, and thank you everyone for your questions and your participation. Some of them bring us back to what the Commission representative was saying on the police checks and internal border controls. I mean, I think the issue there is implementation. Of course, in the European Union, we have a number of very important standards concerning, privacy and, in not all in EU member states, independent justice systems, but still in a majority of member states we do have. But, the increasing, as Evelyn was showing in your presentation, the increasing access by police authorities to databases and law enforcement to EU databases and information systems needs to be very carefully monitored and scrutinized so that we don't end up in a scenario where surveillance becomes de facto not an obstacle for mobility, but mobility takes place under constant surveillance, constant generalized surveillance, which is incompatible with constitutional and EU treaties, And I think this is a particularly crucial issue. When it comes to desecuritization, this is something I wanted to come back to as well, because one can agree that, since the very beginning, since the very first steps of Schengen, that was an embryonic part. Policing was an embryonic part of the Schengen Agreement and the Convention implementing it, meaning the so-called compensatory or flanking measures, all the set of security instruments that were called by ministries of interior to, let's say, go along with free movement. And if I were to identify a game changer, was 2013, when we have the new Schengen governance package introduced, and you had the European Commission having more enforcement powers and coordination powers on the evaluations mechanism, and the conditions for member states to reintroduce internal border controls. And I can tell you, ministries of interior were not happy about this. And since then, they've taken every chance to challenge the Europeanization, the Europeanized system of evaluation and accountability. And this is where the enforcement gap comes in. Schengen is indeed not in crisis. We never left Schengen, in fact. What has happened is a lack of enforcement of rules which are very clear and conditions that member states must comply with when introducing border controls. Now, on the so-called secondary movements, we have absolutely no evidence. And here also, the 5 member states which have reintroduced internal border controls in the name of that time, the so-called migration crisis, have provided no evidence whatsoever on the scale of how onward movement of people inside the EU is not justified or legitimate. By this I mean that most often than not, the reasons why people move inside the EU, asylum seekers, is for very good reasons, meaning inhuman or degrading treatment, lack of reception conditions, destitution, lack of housing, family links, and so on. So using so-called secondary movements to justify, again, member states have failed to provide evidence on the necessity of these internal border controls. And here also we see an enforcement gap. Why those member states have not ended up before the Court of Justice in Luxembourg? We have very little information on how the Commission, coming back to one question, is following up with each of these member states in terms of really providing the necessary evidence and the proof that how they are implementing those restrictions, are they proportionate, are they necessary, are they having any impact in practice? And of course, even when the link to terrorism, I think the burden of proof should be even higher. How a formal border control would play out in the prevention of terrorism. Again, member states have the obligation to prove how that works out and how will that be effective. And the last point on the new pact and the complaint mechanism, I think that the new pact only foresees a complaint mechanism in the border screening, pre-border screening. And I think this is problematic. There should be an independent complaint mechanism in the context of border controls and surveillance generally, independent from Frontex, independent from national border and coast guard authorities, and running in parallel to access to effective remedies before independent judicial authorities as well, which, as we are seeing, is a key challenge at the moment with the pushbacks in many member states and hot returns, and the current discussion on Frontex accountability for fundamental rights violations.
Thank you very much, Sergio. Lenka, would you like to comment?
No, sorry. No, it's fine.
Okay. Evelyn?
Yes, thank you. I would like to raise 3 additional points also in reaction to what Matthias Uhl mentioned and the questions. First of all, I think it's quite important to not use the narrative of Schengen is in crisis to develop or emphasize the further use of technologies controlling people within the territory. I think we have shown and we established in different reports when Schengen is in crisis in the sense that member states are misusing their powers of reintroduction of border controls, there are tools to limit that, control that. The Commission has power to remember member states of their obligations, to start infraction procedures. And in fact, we have now an important case before the Court of Justice with regard to Austria and the prolongation of internal border controls. So I think we should not forget about tools we already have if we think we are in Schengen. And second, my concern about this further use of technologies and databases, I do agree we have a very strong legal basis in the European Union with regard to the protection of fundamental rights, protection of non-discrimination, and the protection of data protection and privacy. But just because of those important fundamental rights, I think we already overreached the boundaries, the limitations of those legal provisions. And I refer to the Court of Justice. There are already important case law judgments of the Court of Justice saying, well, you have to prove that your measures are strictly necessary. You have to prove that your measures are proportional. And to be honest, already considering the large-scale databases we have, the 3 we have added to the 3 we already had, the interoperability, the possible use of facial recognition, the inclusion of biometrics of children of 6 years and older, which I didn't mention in Visa Information System. I do already doubt whether they are in accordance with those important rights we have in the European Union, also because the effectiveness can be doubted. I wrote a PhD in 2007 on the Schengen Information System, and I interviewed police agents. And the Schengen Information System, even if it has its flaws, is a very limited tool in the sense it was, in the beginning at least, with specific categories of persons included in the system for specific tools. So the authorities, police, immigration authorities, judicial authorities knew for which target persons were included. The large-scale databases and interoperabilities has increasing risk that people do not know, and I mean really the authorities of the EU member states, why are those people in the systems? Is the data still reliable? And who are the users? So I'm also concerned about effectiveness for ensuring security and preventing illegal immigration threats. And finally, my point is that even if the data protection standards would be sufficiently guaranteed, it still emphasizes the bias in the community, in the society, that we apparently need those databases only on third country nationals, and we allow police authorities in the borders areas to control data on people who are possibly illegal migrants, which strengthens the bias against people with a foreign origin, with ethnicity. And this was already in November pointed out by the UN Rapporteur on Racism. And I think that's an important signal. This report, I would like to emphasize that the European Union should take this into consideration, the problems of those further tools concerning third country nationals. Thank you.
Thank you, Evelyn. Michela, would you like to comment?
Very few to add to what has been already said. I do agree with what said or was mentioning before. And what I was trying to emphasize was that it seems that the European Union, in particular the European Commission, is trying to somehow find solutions which have to be found internally elsewhere. And this is something that cannot be done right now, in particular because of what I was saying before, we are facing many crises, all of them are internal. Crisis meaning in theoretical, on the theoretical point of view, on the ontological point of view, they have to be faced internally. So Matthias Hall was right when he said that there are many parts of the European Union which are not complete, and this is most of the problem that we have in dealing with a space such as the Schengen space. And then it is right there that we have to focus on the asylum reform, the Dublin regulation, but all these are internal. Regardless of this, it seems to me that we are still relying largely on external measures, and this is simply not the right answer to be provided. So we are just shifting elsewhere the problem and the answers. So we are not going to cope with what is happening internally, and this is creating some problems to the European Union, also in terms of the means that we have to find out to cope. The lack of trust we have to build internally, and not by relying on external measures and on the fear of migrants which are arriving, which they are clearly not. The numbers do not justify the measures that have been undertaken for years, at least since 2015, in an absolute way. So just to keep the focus on what is happening today, to try and figure out possible solution to what the European Union is experiencing today, which is an ontological crisis, to put it. Thank you.
Thank you very much, Michela. And thank you again to all the speakers for such great contributions. I will have to finish right now because we ran out of time. But before we finish, I would like to tell you that this is the last webinar of 2020. Sorry, the next one is on January 13th at the same time, and it will be on the borders, mobilities, and immobilities in Southern Africa. Sorry, well, thank you for joining us, and hope to see you soon in more of our events.